viewers, welcome to the second session on concept of law. This pertains to course Understanding Gender and Law, course code BGS 011. We have, in our first session, we had discussed about the concept of law and what is the nature of law, which is as conceived by various philosophical schools like natural law school or legal positivism, the view of the historical and anthropological school and sociological school. Now, we will be continuing with the other philosophical aspects of the law, and not only we will discuss about what is the nature of law as defined by other schools of thoughts, we will also discuss the nature and objects of law in today's context. So, the history of, if we talk about the history of law or a legal development in any society in any age, is the history of society itself that prevailed in that age. Now, law can be said to be made of precepts, techniques and ideals. Law, as per the English analyst jurist, is the aggregate of laws, and a law was the authoritative rule of conduct to govern the individual. Now, the Greek philosophy and Roman jurists, they also define law in terms of rules to maintain the legal order. Now, as per Justice Holmes, law from the standpoint of view of counselor explaining the clients, their rights and liabilities will, however, means law is prediction of what the court or administrative agencies will do in a given particular state of facts or situation. The modern jurists are now, they are accustomed to see a word which is ruled by law and legal coercion that have been in existence from the beginning of time. Now, the objective of this session, however, is that we will discuss the nature of law in the 20th century as per various philosophical schools, which has taken various shapes such as revival of natural law, American realism, Scandinavian realist, Marx theory of law and state, critical legal studies and feminist jurisprudence. Now, how the revival of natural law can be seen in 20th centuries? Like in earlier session, we have discussed about the natural law says that it is a will of God, it's based on the morals. So, in 20th century, in its modern incarnation, the natural law becomes an evolutionary ideal and thus as a directive force in the development of a positive law. Now, Duggett, he emphasized and re-established overriding principles of natural law in the name of solidarity. Now, similarly, Lon L. Fuller, he is a post-positive lawyer. He advanced the theory of procedural naturalism. Now, procedural naturalism and believed that in all theories of natural law, central point is to discuss or to discover a process of moral principles. So, it is a central point. He had given 8 principles which make any legal order sound and just. So, they are summarized below, like we can say laws should be general, they should be promulgated, that citizens might know the standards to which they are being held. The laws should be, the retroactive rule making and application should be minimized. Law should be understandable, they should not be contradictory, laws should not require conduct beyond the abilities of those affected. They should remain relatively constant throughout the time. So, there should be a congruence between the law as announced and their actual administration. So, law, which is it has given the principles of law, 8 general precepts. It says that it should be promulgated and the citizen should know the standard to which they are held. So, it is based on the morality. So, the morality has been treated as a central point to discover a process of law. In natural law and natural rights, now this is a book which is given by a Feminist. He says that natural law provides the rational basis for the activities of legislator, judges and citizens and furnishes a guide to decide whether we have a moral obligation to obey the law in a situation where a positive law may diverge from the ideal standard of law. So, what is the rationale behind the natural law is that it is still has to be used in formation of certain laws, because they should be based on moral, because they provide the rational basis for the activities of legislators, maybe even for the judges, and it provides it's a moral obligations if are there, then the person will also obey those laws. Now, in legal realism, if we look into it is an approach that law consider the real factors to understand the nature of law. So, when we look into the revival in the 20th century of the law, and then which is propounded by the Feminist or a Duggett, the legal realism is very important to look into. This is an approach to law that considered real factors to understand the nature of law. The approach by positive law theory, basically it focuses on the formal rules, whereas the natural law focused on the moral aspects. So, what is the difference is basically between the natural law school and legal realism is that legal realism is a approach is focused on formal rules, but natural law is focusing on the moral rules or a moral aspects. So, legal realism suggests that apart from the formal rules and morals, one more aspect needs to be taken into consideration, and that aspect is human factors. So, what legal realism approach is that okay, moral is okay, fine with that, while our formal rules are also taken into consideration, but the human factor is very important. So, the realist school concentrate more on what the court actually does. So, their approach is towards the how the courts take into law and how the courts actually do in reaching the final decision and evaluates any part of law in terms of its effects. So, basically their focus of legal realism is on the law which is as expressed by the or as evaluated by the courts. So, the realist school has been divided into two parts. One is the Scandinavian realism and another is an American realism. Now, American realist is a combination of analytical positivism and sociological approaches. So, American realist is, on the one hand, they believe in analytical approach, which is a positive approach, and to some extent they also take into account the sociological approach in defining the law or the concept of law. So, American realists is focused on empirical factors underlying a legal system. So, realist thinking was introduced to the American jurisprudence by Oliver Wendell Holmes. According to him, the life of law is logic as well as experience. So, it's not only logic which is applicable, but the experiences are also very valuable. The real nature of law cannot be explained by a formal deductive logic. You cannot have a formally deductive logic one which you can explain the law, but no, it should be based on some sociological approach also. So, judges also make their decisions based on their own sense of what is right. So, when the judges are making decisions, sometimes there is one approach which says the case laws, the judge also make laws, though generally it is with the domain of legislature, but the judges make decisions based on their own sense of what is right. Now, Justice Gray, he is a great pioneer of legal realism. For Gray, the law was simply what the court decided, and everything else including statutes was simply the source of law. So, he says no, whatever statutes is making, that is the source of law, but the law is basically the court is deciding. So, Holmes however believed that law does not work in a mathematical accuracy. So, it is not always possible to have a logical deduction or a mathematical deduction for analyzing or deducting the law. Now, another jurist, Jerome Frank, he supported the Holmes, and he is also of the view that law does not work in a mathematical accuracy, and he said that certainty of law is a myth. For example, if we approach a lawyer with a case in a hand, now he will tell us the chances of winning, but he cannot with all the accuracy predict the outcome of a case. So, whenever we are approaching, naturally the lawyer also make its opinion or form its opinion based upon the rules, existing laws and facts and circumstances, but he cannot predict with accuracy that yes, they will 100% win. So, many times lawyers will tell the clients that the outcome of the case depend upon the judge who will decide it. So, the view of Gray and Holmes is that law cannot be deducted mathematically, and it should be the court has to decide based on the circumstances and facts of each particular case. Now, but the Scandinavian realists, they says law is nothing but social facts. So, they clearly came to the terms with social facts. This is the rule of law or independent imperatives which is issued by time to time by various constitutional agencies. Now, it says it is a totally independent and is issued by a constitutional agency and nothing but social facts, they show what are the social facts existing at a time. So, theorists like Hagelstorm, Oliver Kroner, Lundstedt, they had contended there are no such things as rules, but that conformity with a rule consists really in habitual behavior which is accompanied by feeling of being bound to act in the habitual way. So, we have also discussed the Austin concept where it says that sovereignty, the law is the command of a sovereign, which is a person who is not obeying, isn't habitually obey anybody else, but the people do obey him. So, Oliver Kroner and Lundstedt, they have contended that there is no such things as rule, but that conformity with the rule consists really in a habitual behavior which is accompanied by feeling of that they are bound to act in that manner. So, Oliver Kroner on legal language and reality, which is a book written by him, he rejected the theory that moral influence the law and vice versa. So, he says he completely was the opposite view of the natural law theory. So, he says that no, he rejected this contention that moral influence the law and vice versa, and he stated that the purpose of all legal enactments, judicial pronouncements or contracts and other legal acts is to influence the men's behavior and direct them in certain ways. So, Lundstedt said that law is found in social needs and not justice. So, basically he says it is basically law is based on the social needs of a society. So, the realist theory therefore defines the law in terms of its actual functioning and operation, and like positivism they look law as the expression of the will of the state, but they see this as a made through the medium of courts. So, what is the view which is given by realistic is like they are also agreeing with the positivist theory to some extent that actual functioning has to be seen in terms of the expression of the will of the state, but the thing which we can say it is added by the or looked into view by the the Scandinavian or American realists is that the law is made through the medium of court. They put importance to the law made by the judges. But similarly, there are certain Marxist theory of law and state. Now, there are various theories of law, and we cannot and there are so many schools which attempt to define law, not only law, the nature of law, but how the concept of justice emerged and how the state functions and a law functions in any capitalist society. So, Marx theory of law and state. Now, Marx and Engels, they believe that capitalist societies and capitalism will give way to communist society and communism, and the society will be classless society. So, basic aim of Marx theory of law and state is that they conceive a communist society, and they say that only capitalism can give way to that communist society, which is a classless society, all are same and there is no classes within the society if it is a communist society. So, law and state as an instrument of domination will be replaced by an administration of things, and law and the state will wither away in communist society. So, their focus is this is if there is a communist society, so law and state, they are the dominating persons, they will dominate how the things should be administered in particular state. So, Marx classifies society into various classes always in conflict, namely capitalist, wage laborers and landowners. So, this classification of society into various classes and concept of state and law by Marxists is also questionable on many counts. But how they are classifying and that there should be a capitalist and wage labor and a landowner. So, this type the classification which was given by Marx theory of law and state. So, it is also criticized by many jurists, but still the Marx sociology has contributed, we can say, a lot towards the understanding of social contradictions, how the social changes are coming within a society. So, the main focus is on the capitalism society and capitalism is a way for a communist society, which is a classless society, which is as perceived by the Marx theory. Now, critical legal studies. Now, critical legal studies is is a very important aspect. It plays in a modern concept of state or a law or a democracy. The chief exponents of critical legal studies are Robert Gordon, Peter Gable, Mark Hellman, Claire Delton, Duncan Kennedy, R.M. Unger and others. The critical legal studies, they have also raised the debate about law, legal institutions and legal reasonings in the overall structural design of a society. Now, critical legal studies is basically of the view that law is influenced by politics. For example, we can see the influence of politics in the way in which state makes law relating to religion. The critical legal studies is is very, I think, in a democratic society, in a today's society, it plays a very important part, because they are raising the debates how the law, legal institutions and legal reasonings they have played an important role in an overall structural design of a society. So, they basically focus on politics, that it says no, politics is also influencing the way in which the state makes law, or basically in the domain of religion. So, it is focusing on the role of politics in the law, or in defining law, or in defining the nature of law, or the new legislations which are coming into being. Similarly, it is very important a feminist jurisprudence. So far what we have discussed is how the natural law theory provides for morality of law, or a legal analytic positivism who says that law is the will of the state or a command of a sovereign. Or if we have also looked into anthropological approaches or sociological approaches which focuses basically on social needs, what are the social needs in a society. Or Marx theories, however, they focuses on the concept of capitalism in a state, but a feminist jurisprudence is also emerging. This is the general theory of jurisprudence, did not differentiate between opposite sex, and in response to feminism, feminist jurisprudence has been developed. Because we are this is a course on, we are discussing concept of law in the perspective of gender justice. So, the course is also titled as Gender Studies in Law. So, when it's very important to understand the feminist jurisprudence, because the theories of jurisprudence, they do not differentiate based upon the sex. So, there are 4 schools of feminist jurists: liberal, radical, cultural and postmodern. Liberal feminism, they believes inequality of sexes as autonomous human beings. Now, they are saying it's an autonomous human beings, and they should inequality of sexes is seen as an autonomous human beings. Radical feminism focuses on women as a class that is dominated by men. So, another class. So, they are making class of women. We are not going into much details of feminine jurisprudence. However, I am just giving a few school of thoughts which divide the feminism into liberal and radical, cultural and the postmodern view. So, the cultural feminism, they stresses on cultural variant of females from the point of their speech, dress and mannerism, and how the laws are also formed taking into account of they should not be they should be gender neutral sometimes, but they have to also, law has to be framed to protect the women's. So, postmodern feminist jurist rejects the above theories. They stress that gender and equality are social constructs. So, they says no, when we talk about gender and equality, they should be treated as a social constructs. However, these schools of thoughts do not they do not serve a very major purpose of building a unified feminist approach of jurisprudence, or nor in building some concrete concept. But the basic aim or basic concept in philosophy of feminist jurisprudence is that they did not differentiate between opposite sexes and this is the law is to develop in accordance for the empowerment of women. So, they do not define the law in that perspective. The functions and objects of. Now, so far we have discussed about various philosophical approaches on the concept and nature of law. We have already seen all the historical schools, how they define law or they perceive law. Now, the functions and object of law, if I have to say in words of Hobbes, I will say it was law was brought into the world for nothing else but to limit the natural liberty of particular men in such a manner as they might not hurt but assist one another and join together against a common enemy. This is given in a Leviathan by the Hobbes, that that it should be law is nothing else but it is to protect the persons, and it is not to harm anybody else, but one has to assist the another and they have to join together against a common enemy. The immediate objects of law, if I have to say, is we have read so much about the laws and how would be the immediate object of law. So, we can say it's the creation and protection of legal rights. The immediate object of law should be provide justice, connoting a logical part of the very notion of law. Law is those just principles that are applied by the state in administration of justice. The notion of law requires uniformity for the stable and secure social order, but at the same time there is also need for flexibility to enable law to adapt with social needs. Therefore, the law is also said to be territorial in nature. So, in modern state, the law consists of rules which can be created by legislature and applied and developed by courts. So, the enforcement of law is generally confined in its application to persons, things, acts, and even within a defined territory of state enforcing it. However, there are also certain laws which are not territorial in nature. Now, for example, state conclude treaties with each other by which the states agree to surrender to the other persons found in their territory who are wanted for crimes committed in the territory of other party to the treaty. So, this process is called basically extradition. However, generally the law is always territorial, mostly territorial in nature, because if for example, if a dispute is happens between the two persons in a particular place, maybe in Delhi or in Bombay, so the jurisdiction of which court will apply. If action arose in Delhi, generally the Delhi court has a jurisdiction. So, basically the law is seen as a territorial in nature, but in some time in extradition cases there are certain laws which are not territorial in nature. Now, sources of law, if we look into, so far we have already discussed the nature or concept of law. So, a little bit knowledge about the sources of law can be shared here with the viewers. It is important that they must know about the sources of law. So, they are formal and material, either legal or historical. So, after referring to writing of different jurists, it can be said that the sources of law may include we can say it could be faith, it could be custom and the common consciousness of the people, equity, legislation, judicial decisions. So, as culled out from various writings, we can say, so the sources of the law may be customs, it could be common consciousness, equity, legislation, judicial decisions. So, legislation is basically a prime source of law, the modern world, which consists in the declaration of legal rules by a competent authority. Parliament, which is parliament. So, legislation is either supreme or subordinate. The supreme legislation is that which proceeds from the supreme or a sovereign power in the state, and the delegated legislation, which is also referred sometime as a secondary legislation or a subordinate legislation, is a law made by the executive authority under the powers which is given to them by the primary legislation in order to implement and administer the requirements of the primary legislation. The subordinate legislations are in the forms of rules, regulations, orders, ordinances, as well as bylaws by the center and the state government and local authorities like municipal corporations or municipalities, gram panchayats and other local bodies. So, legislation is the authoritative source. So, in India the doctrine of parliamentary supremacy exists, and all forms of legislative activities which is recognized by law other than the power of parliament, they are considered as subordinate and subject to the parliament control. Now, while deciding a case and pronouncing a judgment, when there is no legislation on particular point, the judges generally apply their own common sense of right and wrong and of justice. This is known as judge-made law or a case law. Such decisions become authority or guide for subsequent cases of a similar nature, and they are called precedents then. The principle by which the judicial decisions became a precedent is known as stare decisis. That means to stand by the precedent and not to disturb the settled point. The legislation is the most authoritative source of law, but the judicial decisions, however, it could be authoritative, conditional, authoritative or persuasive precedents. So, law we can say is an instrument of change, but its efficacy varies according to the conditions present, and the aim of law reform is to examine existing laws with the aim of maximizing justice and responding to the changing values and concerns within society. So, we can summarize the nature of law after going through the sessions as law as the dictate of reason by natural law, command of sovereign imperative law, law as the practice of court legal realism, positive law is the rule of ordinary human law, law is a means to creation and protection of legal rights, justice, stability and peaceful changes. Law is to maximize the fulfillment of interest of the community and its member and to promote the smooth functioning of the machinery of a society. Law is territorial in nature with some exceptions to the rule of law. However, legislation in maximum in all the countries is the authoritative source, though judges do make law, and that is also a debatable issue, however. So, with this a very thanks to the viewers, to the listeners, and with this we wind up with this we have already discussed the concept and nature of law as per the philosophical theories and what exists in the modern context in India, but particularly in India. Thank you.